Okay, then, we will go to our second case on the docket, case 17-3301, Shannon and Carol Shannon versus Deutsche Bank National Trust Company as trustee for Morgan Stanley, et cetera, et cetera.
Good morning, Your Honors. My name is Ryan Torrens, and I represent appellants in this appeal. I would like to reserve 5 minutes of my time for rebuttal. Your Honors, the trial court erred in entering a final judgment of foreclosure in this case. The trial court erred for two primary reasons. The first reason is that on the second allonge in this case, there is an endorsement from the original lender in favor of New Century Mortgage, and then there is a second endorsement, which is an endorsement in blank, not from New Century Mortgage, but from New Century Mortgage Corporation. Because this last endorsement, the endorsement in blank, is not from New Century Mortgage, but rather is from New Century Mortgage Corporation, this constitutes an anomalous endorsement under the statute 673.2051 sub 4.
Was there any evidence presented at trial that these were not the same entities?
No, Your Honor, there was not any evidence whatsoever tendered at trial, and what I submit to the court is that that was the burden of the plaintiff, that and the appellee in this action. The affirmative defense of lack of standing had been raised by Mr. Waslick, who was trial counsel in this case. Mr. Waslick had specifically alleged in his affirmative defenses that the promissory note was not properly endorsed in favor of the appellee in this case.
And what cases do you have to support that it is the presumption of the bank to show this and not you, to show that it was not properly endorsed?
Yes, Your Honor. Cases like Winchell from the 2nd District, which was actually cited in our reply brief. And what Winchell states is that when lack of standing is put into the case, so to speak, by raising it as an affirmative defense, the burden then shifts to the plaintiff, which would be the appellee in this case, to prove standing as a part of their prima facie case. Mr. Waslick, trial counsel, not only raised it as an affirmative defense, but this was argued extensively at trial, lack of standing. He moved for the entry of an involuntary dismissal on the basis of lack of standing, and then subsequent to the trial, moved for rehearing on lack of standing. And so once that has been injected into the case, in the words of the Winchell court, the burden does then shift. I believe that in this case, in the case at bar, appellee's counsel is improperly trying to shift that burden to the Shannons. And so we believe that this is an anomalous endorsement under 673.2051 sub 4. At trial, as I just stated, there was no evidence whatsoever tendered by appellee that there was any link between these two companies. There was no evidence that they were one and the same, and there was also no evidence, alternatively, that New Century Mortgage Corporation had the legal authority to endorse this note on behalf of New Century Mortgage. If a power of attorney or something along those lines had been introduced into evidence, we wouldn't be advancing this argument. The appellee had to prove either that New Century Mortgage Corporation had that authority to endorse the note on behalf of New Century Mortgage, or that they were one and the same. And cases have come about before in the Florida appellate courts where we have discrepancies in names. And one case that I would like to refer to is the Hyslop case, which was referenced and relied upon in the initial brief. And in Hyslop, a final judgment was reversed by the 1st District Court of Appeal because there was a discrepancy in the names that were in the complaint and then in the name that was in the final judgment.
What was that discrepancy?
And the discrepancy was actually, the names were very close. The discrepancy was in one of the documents, I believe the complaint, it was Allstate Fabrication, but the judgment was Allstate Fabricators. And what the 1st District said was because there was no evidence admitted that they were one and the same, that they were not comfortable affirming that judgment and that it had to be reversed. And because of that, they reversed it. Here, we have a discrepancy in the names, but not only that, the names come in on the endorsements. And this second allonge and the endorsements contained in the second allonge is what was relied upon by appellee's counsel at trial to try to latch on to the Ortiz presumption and prove standing at trial, and eventually is what the trial court relied on in entering the final judgment of foreclosure and finding that the appellee had standing to foreclose. And so it's really a critical issue. It's not just semantics. This is how the plaintiff argued standing at trial.
So is your point that the signatures themselves were not authorized?
No, Your Honor. The argument that we're advancing here is not that the signatures were not authorized. It is the case that the signatures on the two allonges appear to be from different individuals. But that's not the argument we're advancing. What we're arguing is that those endorsements are anomalous and therefore have no force in effect, that they are not legally enforceable and legally valid. We are not challenging the signatures, and those two are separate issues. If that second endorsement had been from New Century Mortgage, then maybe they match up, but you still have the issue of the first allonge, which makes this case unique because you had the first allonge which came into evidence after being introduced into evidence by the defense.
Well, so the first allonge, they could have just given it back to Nationwide, right?
Correct, they could have, Your Honor, and that's one of the problems in this case is that plaintiff didn't prove that that actually happened. And so the appellee failed to prove standing. And that actually leads into the second argument for reversing the judgment below, which is that after defense counsel requested that the allonge from the first case be admitted into evidence, the trial court admitted that allonge into evidence. And what that showed is that in the 2009 case, that this note had already been negotiated by the original lender, Nationwide, to blank. That was the same trust in the 2009 case, and that note had already been negotiated.
So what makes an allonge an allonge? What makes it valid?
Your Honor, what makes an allonge valid would typically be that the allonge was attached to the note.
So was the first, what we're calling the first allonge, was actually not an allonge, correct? Because it's not attached to a note at this point.
Well, and this leads to the problem that I believe the appellee has in this case, is even the trial court on the record stated, well, wait a minute, how could there be two allonges? And when we don't know which one actually was attached. Now, in the appellee's answer brief, the appellee states that it could have just been a mistake, and is basically speculating in the answer brief as to what could have possibly happened with this first allonge. And this is a unique situation, but this was admitted into evidence, the 2009 complaint that attached that.
The complaint was ultimately dismissed.
It was voluntarily dismissed. That is correct. Right. That is correct, Your Honor. But this 2009 complaint and the note and the allonge from the 2009 case came into evidence and is contrary evidence compared to the second allonge because it shows that the note had already been negotiated. Now, when we get to the second allonge, the only way it can go from the original lender again is if it had been negotiated back to the original lender, and there's no evidence.
They have just given it back? Isn't it a bearer note at that? Can they just have taken that, we use the term the first allonge that's in blank from the original lender Nationwide to, I guess, the first plaintiff in 2009? Couldn't that first plaintiff just have given it back to Nationwide?
Your Honor, I think that...
I think it seems like your argument is, well, we don't know that that's what happened, and therefore that's part of the reason you say you win today. Is that right?
It's part of the reason in that it was the burden of the appellee and not the burden of the defense to prove that. But also, once that note has already been negotiated by the original lender in favor of blank, what that complaint demonstrated was that it had already been negotiated to the trust.
So just because it was in the complaint and filed, it's presumed correct?
Your Honor, we believe that it's presumed correct to the extent that it at least defeats plaintiff's claim for standing, constitutes a fatal break in the chain that plaintiff needs to prove its standing.
So 7 years ago, they file it with the blank allonge number 1, and then in 2016, the new suit's filed with allonge number 2. You're saying allonge number 1 couldn't have just been given back by trust to Nationwide, and then Nationwide gave it to, transferred it to New Century, and then New Century then endorsed in blank. I mean, that's kind of what your opponent is saying has happened, right?
Your Honor, that's actually not what our opponent has said has happened. At trial, they had no evidence as to what happened. They actually showed up at trial with only the second allonge.
Okay, but they have it. They're physically they have the note in the allonge, right, when they filed suit, and they have it at
They-
trial, right?
They had the second allonge that was endorsed from the original lender.
And they have the original note, don't they?
They did.
Okay,
But-
when they filed suit 2, and then at trial, they presented the original note and the second allonge, right?
That is correct.
So another, maybe a better question, if there was no first allonge, then your only argument here today would be, well, New Century Mortgage and New Century Mortgage Corp. We don't know that they're not different entities, and the plaintiff hasn't met its burden of proof, therefore, there was no standing.
Your Honor is correct in that if there was not the first allonge, that would be the only argument we would be
Your argument
advancing
here
today. And this case being a unique case, and I believe a uniquely problematic case for the appellee in terms of standing, with that first allonge is at least enough to defeat this Ortiz presumption. Foreclosing banks often try to latch onto that Ortiz presumption, and Ortiz does carry the day much of the time. But what Ortiz states is that that works when there's an absence of contrary evidence. And when you have this negotiability issue where it looks like it had already been negotiated to the trust, and then you have the second allonge, you also have the issue with New Century Mortgage versus New Century Mortgage Corporation. And Your Honors, additionally, there is a Florida statute that I know Your Honors are well aware of, 607.0401 sub 1, and this statute does require that a corporation identify itself as a corporation or as being incorporated or something of the sort. Here, we only have New Century Mortgage. We don't know if it was an LLC. We don't know if it's a different entity. The plaintiff tendered no evidence to prove what type of an entity it was or if it was linked to New Century Mortgage Corporation. Obviously, this court nor the trial court can make assumptions as to whether there was any link there that needed to be proven by the appellee. The appellee failed to do so, and I believe that that requires the judgment below to be reversed. Additionally, Your Honors, as in terms of the proper remedy, should this court agree with our contentions and proceed to reverse the judgment below, we believe that the appropriate remedy is an involuntary dismissal of the complaint. This was addressed on both sides in the briefing. I know counsel for appellee has claimed that the appropriate remedy would be a remand for a new trial, but the case law that is relied upon by the appellee is actually a case with dealing with amounts due and owing, where there was a remand for a determination as to the appropriate amounts of due and owing. This court has been consistent, as well as your sister courts, in finding that when there's a reversal for lack of standing, that it has to be a remand for the entry of an involuntary dismissal. And so we believe that that would be the appropriate remand in cases such as Fielding, where this court held that an involuntary dismissal was required for lack of standing. And so with that, Your Honors, that concludes my argument, unless the court has further questions, and I would like to reserve the remainder of my time for rebuttal.
Okay, thank you, counsel.
Thank you, Your Honors.
Good morning, Your Honors. Allison Murat for the appellee. This is a mortgage foreclosure appeal. The loan has been in default for a decade. There's no dispute about that. Instead, we're here today to discuss issues that were not raised in the trial court. We're talking about arguments that were not presented at the non-jury trial. The law does not permit this. The law is well established that you can't raise arguments for the first time on appeal. This is not a case.
What arguments is your opponent raising for the first time on appeal?
The anomalous endorsement argument, Your Honor. The issue that of the missing word corporation on the endorsements, and the issue that the second allonge has anomalous endorsements. The issue at trial was attachment.
But isn't this a sufficiency of the evidence argument made by counsel?
Your Honor, and that would go to Rule 1.530E. 1.530E does not cover the arguments in this case because that's about the sufficiency of the evidence. This would be a legal determination, a legal defense, a factual defense that would need to be presented to the trial court. It could have easily been presented to the trial court, fleshed out, refuted, and then raised on appeal, but it wasn't. This is the first time we're hearing of this argument. The Shannons rely on their answer for preserving the defense, but the anomalous endorsement issue was never raised in the answer. A proper defense would look something like, yes, you have presented facially sufficient endorsements, but there's really another allonge out there that negates your second allonge. We're calling it a second allonge, but the allonge with the current complaint. Or, yes, the New Century endorsements are facially valid, but there's really two different companies with similar names. Those issues or arguments, defenses were never raised in the answer. And that's why these are issues, these are factual defenses, these are legal arguments, legal determinations about the legal sufficiency of the endorsements is not covered by 1.530E. However, even if the court disagrees with that, the court should still affirm. And I'd like to discuss each point separately. Even if the Shannons preserved their argument, and even if 1.530 allows them to raise these arguments, the trust presented enough proof to prove a prima facie case. And that's the standard that we're talking about, a prima facie case. So once you've presented a prima facie case, the burden then shifts to the defendant to present some type of contrary proof or to refute the prima facie case.
Counsel, what effect, what weight, what significance do you think the previous allonge had in this case?
I don't think
it's not an allonge anymore, correct? Because it's no longer attached to a note.
I don't think it has any effect, and I don't know that it's an allonge because we don't know that it was ever attached to the original note. And we're talking about reasonable inferences that can be drawn in favor of the non-moving party, which is the plaintiff in this case, when you're talking about involuntary dismissal. And here's a reasonable explanation. The Shannons took out a loan, the original lenders Nationwide. Nationwide has the original note. They execute an endorsement to New Century Mortgage on an allonge that's affixed to the note. New Century then executes an endorsement in blank. The note's lost. 2009 complaint is filed with a lost note count. In that complaint, plaintiff says, we don't have the original. We don't have the note. We don't have the original or the allonge. If you look at the 2009 complaint, it has a copy of the note attached, but it's not a copy of the original. It's a copy of the original. So the plaintiff at the time didn't even have a copy of the original note. It could have been a copy from the origination day of the loan. And then an allonge is included with that copy. We don't know that that allonge was ever affixed to the original note. The original note's found. It's filed in the 2009 case, and that's the allonge in our case, the New Century allonge, is affixed to the original note. Suit, it's voluntarily dismissed. Suit is filed again. We have the New Century allonge attached. The trial judge in this case examined the note closely. The judge put on the record, same color paper, same hole punches, same staple marks. This allonge is the one that's affixed to the original note. The 2009 allonge, we don't know if it's even an allonge. It appeared with a copy of a note with a lost note complaint when they didn't know where the note was. So I think that negates any argument that the plaintiff is bound by a document with a blank endorsement that was included with a copy of a note that was lost. And we're talking about a fact-finding function that's within the province of the trial court. The appellate court's not a court of first impression. This isn't the right place to be fleshing out these issues or making factual determinations about which allonge was really the right allonge. Do you have any other questions on the issue of the 2009 allonge versus the New Century allonge? And the position, I think, the reasonable position is that the New Century allonge is the first allonge and the only allonge that's affixed to the original note. And going back to the issue of the New Century endorsements and the missing word corporation in the first endorsement, this issue is controlled by the decision of Avant Capital v. Gomez. That's a 4th DCA case that came out in September of 2018. I filed it as supplemental authority in this appeal. It was not addressed by the appellants in their reply brief. It's directly on point. In that case, there's a mortgage company,
Is it in your
Providian.
answer brief?
I'm sorry?
Is it in your answer brief?
No, Your Honor, it came out after I filed my answer brief.
Oh, that's right, this is 2017 case, all right.
Yes, Your
Go
Honor.
ahead.
So the word corporation was missing from the note. So you have Providian Mortgage Corporation, the word corporation is missing, and the court said that the missing word corporation did not render the note invalid, and the court pointed to Florida Statute 694.12. And that statute says, omitting a word from the corporate name on an instrument does not render it invalid or ineffectual. The Gomez Court, the 4th DCA, also cited to the 3rd DCA case Presley, which I did cite in my answer brief, which follows the same reasoning. And in the Presley case that says slight departures in names generally will not affect the validity of contracts or other business transactions. So this issue of the missing word corporation, it's a non-issue. In the absence of any conflicting evidence, any argument that these are two different entities, the trial judge would not blink at this endorsement and think that these are two different entities. The trial attorney for the Shannons didn't raise the issue. This is the first time we're hearing of it. So in the absence of any contrary testimony, certainly the court could reasonably conclude that New Century Mortgage is the same entity as New Century Mortgage Corporation.
When did you file your notice of supplemental authority?
It was October 8th, 2018.
For some reason,
I have a copy with the filing stamp on it.
we have it. Thank you. We just
Okay.
couldn't find it on the date.
And I believe this case was stayed for a while because of a bankruptcy, and then the reply brief was filed sometime later by a different attorney. But this case was not addressed in the reply.
Go ahead.
So I believe that Avant Capital v. Gomez spells it out clearly, but the same principle is discussed in the Presley case that was cited in the answer brief, and Presley was not addressed at all in the reply brief either. So because the trial judge could conclude, looking at the evidence, looking at the note, looking at the endorsements, New Century Mortgage is the same as New Century Mortgage Corporation, the trust presented prima facie evidence of its standing to foreclose. At that point, it became the Shannon's burden to disprove standing and show that these are really either two different entities or one doesn't exist, and that did not happen. Do Your Honors have any questions?
No?
Okay, then I would cede the rest of my time and ask that the court affirm the judgment.
Thank you, counsel.
Thank you.
Okay, Mr. Torrens, you have 7.5 minutes for rebuttal.
Thank you, Your Honors.
Counsel, I'm going to actually start you off and ask you to address the preservation argument because there's an argument to be made about sufficiency of the evidence, but there is also an argument to be made that this was very factual issues that were not raised before the trial court. Things like, is this the same entity? Is this the right note? All of these type of things. So how do you think not raising those specifically below is not an issue for you?
Yes, Your Honor, I'm happy to address that, and I'm glad you brought that point up. So first, this court has been quite clear that when it is a judgment that is entered from a bench trial under Rule 1.530E, when the challenge on appeal is a sufficiency of the evidence, even if the specific objections were not raised at trial, that they can be raised on appeal. The cases that were cited in the answer brief by the appellee in support of their waiver or lack of preservation argument were all jury cases. Obviously, 1.530 doesn't apply in the jury context. I would like to bring up a couple specific cases where this court has addressed this issue. One of these cases is the Delia case, and this is actually a foreclosure case where the final judgment of foreclosure contained no indemnification language, and it was a lost note case. There was no language indemnifying the borrower in case another bank tried to sue them on the note. This issue was not raised at all at trial, but yet not only did this court entertain the issue, the court reversed and remanded with instructions to enter indemnification language or otherwise put language protecting the borrower. Also in the case of Fielding. In Fielding, just like in the case at Barr, lack of standing was raised as an affirmative defense. But unlike our case here in Fielding, a trial counsel actually did not object on lack of standing at all at trial. It was only raised as a defense. Here, trial counsel objected vigorously on the basis of lack of standing at trial. It was raised as a denial to the allegations in the complaint on standing and as an affirmative defense. So even in a case where standing wasn't raised at all at trial, in Fielding, this court held that that issue was properly raised before this court, and this court did reverse on lack of standing in that case as well. Also, I mentioned Winchell earlier. Once lack of standing is injected into the case, the plaintiff, in this case the appellee, is put on notice that it needs to have its case tidied up in order to prove standing. When you have New Century Mortgage versus New Century Mortgage Corporation, you have a prior filing that presumably counsel would know that there was a prior filing. These are issues that need to be squared away as counsel's preparing for trial. So I think there certainly was sufficient notice that the appellee needed to be ready to prove standing.
Are you familiar with the fourth DCA case that the appellee mentioned, that she filed a supplemental authority?
Yes, Your Honor. I reviewed that case some time ago, and what I would say is that that case is easily distinguishable because the argument that we're submitting to this court is not that the note is invalid or that it's a note that can never be enforced. What we're arguing is that these issues that we've raised with the differences in the names and the differences in the allonges constitute a fatal break in the chain as to plaintiff's standing, that the plaintiff has to make this chain as a part of its burden, as a part of its case in chief to prove standing, and they failed to do that in this case, and that's why the judgment below should be reversed. We are not asking this court to invalidate the note or anything like that. And so I think that case is easily distinguishable. And even Presley, which was referenced by counsel for appellee, is distinguishable as well because that was a special concurrence. And as was noted earlier, concurrences might be interesting to read, but they don't contain any precedential value. And so that's what I would say about that. And also the last thing that I would note, Your Honors, is that with all due respect to counsel for appellee, when counsel asked this court to reasonably assume basically that those two companies are the same, something along those lines is what counsel said. Obviously, neither the trial court nor this court can support a judgment with assumptions. We can't stand here and say, well, the names look pretty close, so we're just going to go ahead and assume they're the same. That wasn't proven. We're dealing with someone's homestead property here, and then the appellee needs to prove its case, and we can't support a judgment based off of those assumptions. So I would encourage this court to decline that invitation to do so and to reverse the judgment below in this case and to remand for the entry of an involuntary dismissal. Thank you, Your Honors.
Thank you, counsel.
Thank you.